afternoon again. So let's start our plenary closing session. We will have the honor to have a keynote speaker, my friend Max Schrems, who arrived from Austria to discover Latin America. And then we will have a panel discussion with all the speakers. We have two more who are arriving. And before we start, let's do this. I suggest you make a small introduction for 5 minutes with Laura, and then we pass the floor to Max for his keynote speech, and then we will introduce the next speaker. And I will leave time for the last ones who arrive. Okay, I'm seeing one of them, Jonathan. Jonathan is arriving. And so we just need one more. Estella is arriving. And then in the end, we will have the closing from Professor Paul Zingales, Nicolas Zingales. Before passing the floor to Laura and Max, I just want to spend 2 minutes to highlight some elements that emerged in the last 2 days of debate. And I want to congratulate and thank everyone because the quality of the debates and interactions here is extremely high. And unless everybody is lying so well, I saw a lot of enthusiasm in the debates. And I always answer, the debates are here because you are here. The debates are good because you are here. We are not going to debate alone. And Stella just arrived, so we have all the speakers here already. But the elements that I wanted to highlight is this. What was evident in the last 2 days that this session will be focused on the evolutions of artificial intelligence and how it relates to the data governance. And what best practices or bad practices can be identified in the G20 in Latin America. I think something that became very clear in the last few days is that artificial intelligence needs to be regulated. We are not debating anymore if it's going to be regulated or not. We need to know how. And also implement and to use what we already have. For example, data protection regulations that regulates the automated treatment of data. We are going to see with Max a crucial part of in his presentation. We don't need to reinvent the wheel, but we need to revalue the enforcement. I think this is something that became clear in the last few days. We don't need to create wonderful regulations and laws if they are not implemented. Even if it seems to all of us who operate in public hearings, in papers, in research, the approval of the law is a milestone and something historical. But this is only the first step of the regulatory journey. And for the regulation becomes effective after its implementation. That this is the most crucial part. And there are other modalities of regulation. In the last few days, we talked about digital public infrastructure. That are not only a good option, they can be a good option to organize digital public services, to reorganize the economy, but it can be also an option. And it is being used an option to regulate through technology. And we need to understand really well the normative values that are embedded in these technologies. We don't need to consider them as a silver bullet or an ideal solution. We need to have a critical approach. We were debating yesterday in the session about AI governance in the G20 that in India, the right to privacy, the fundamental right to privacy was created because of digital public infrastructure was being used to a massive violation of rights all over the country. So this violation, this abuse of a digital public infrastructure led to the enactment of the fundamental right to privacy. So we need to be very critical about this. And the last point that brings me some elements on how to organize CPDP LatAm next year. The debate about digital public infrastructure is something that became a fad because of India. One of the first evidences that leadership from the global south become relevant worldwide. Secretary Luana Lukarachi said that in the new strategy of digital government, this term digital public infrastructure is there present, and it was not in the framework before. We didn't have a global debate about digital public infrastructure without India. Before India included that, it was a joint declaration, of course, but it was a successful Indian lobby. And we need to understand that the knowledge sources, the classical knowledge sources, what is happening in Europe or the business models in America, they are not the only ones that we have to look at. It's really interesting to look at the G20 this year because we are the president of G20, but next year we are going to be the president of BRICS. The BRICS is a G5 or a G11 of the largest developing economies in the world. So maybe next year we can look at not necessarily the classic ones, but the leaderships that are emerging in the global south. Having said that, I'll pass the floor to Laura. And then we'll have the best part, Max Schrems. But now I'll pass the floor to Laura. Thank you, Luca. First, I want to congratulate you, congratulate Nicolo for once again organizing CPDP LatAm to foster this regional agreement. And I want to congratulate everyone for participating and greet everyone in the table. I think it was one more successful event. I participated last year, and I agree with you. The quality of the debates was amazing. And maybe the most debated topic this year was AI. Of course, we had many others, but artificial intelligence was a subject that was present in many different panels. And I think this is important for the region as well. Thinking at first in Brazil and in the architecture that we are building, I think this was mentioned many times. I think that we moved forward in the last few years. We are building an architecture of data protection, an institutional architecture, following many countries in the region that already had laws and institutions and authorities. Brazil has approved the LGPD in 2018. It came to effect in 2020, and then we had the National Protection Authority, Data Protection Authority. In the same year, we had a decision from the Supreme Court recognizing the fundamental right to data protection, and then we had this fundamental right to data protection recognized in the Brazilian Constitution. So I think this trip was important to Brazil, and it came right after our neighbors that already had institutions and frameworks in place. But this shows that from one side, we need to consolidate this institutional system. So it's not enough only to have the law. We need to consolidate this system. We need to strengthen our National Data Protection Authority. We need to make this law move away from the paper and to be actually applied. And we need these fundamental rights to data protection recently recognized and enacted can be also applied. And in this trajectory, we are realizing that especially because of this technological revolution, especially the generative AI, is that in one side we need data protection, that data protection can meet many of these challenges. and overcome many of these challenges. And most of what AI uses are personal data. Therefore, we have some instruments present today in the general data protection regulation. So, on the other hand, a large part of the inputs are not personal information, and a large part of this brings other challenges that goes beyond the data protection, Brazilian or otherwise. And this is where our discussion comes into play, the necessity to regulate AI. We saw that besides regulating and debating the personal data and its treatment, we need to see the whole life cycle of artificial intelligence. Since the data treatment, since the training, data training, going through the creation of these models and the application and the prediction and the automated decisions. And in Brazil, we have a strong decision for 4 years about the necessity to draft an AI regulation. Today, it is consolidated in the Bill of Law 2338. We have many different bills of law, but the most advanced one, the most robust one, is this 2338 that comes from a legal experts commission in the Federal Senate that I had the honor to be the rapporteur. And today, the rapporteur is Senator Eduardo Gomes. So yesterday, this temporary commission was postponed. And to me, it seems that the topic that we are discussing from one side is the consolidation of the data protection system, and in the other side is the uh, drafting of a new regulation, of a new system. And as Lucas said very well, we already have the consensus that we need to regulate AI. And this consensus, as I saw in the discussions here, certainly is present in Brazil, and we are building this consensus regionally. Of course, that the path to reach this regulation is exactly what we are discussing today. What is really clear to me, and I saw that some panels mentioned that, is that as a region, we need to think from in the governance of the systems, because you consume most of these systems. We are large consumers. We are not large developers. And we need to be sure that these systems are applied in our country in different areas, respecting the fundamental rights, respecting the personality, the freedom, and the autonomy of people, especially the equality of everyone. Both from on the other side, I think it is important that as a region, we need to think in the governance on how we consume and implement these systems, and also we need to think how to innovate as a region, how to foster innovation. And I think this is a consensus that we can realize, is that we observe from our own experience that not doing anything and not regulating does not generate an automatic innovation.
And I think we can see this from the experience we have today. Not doing anything did not create substantial innovations. So we also need different kinds of support. We need a structure that allows for this innovation. And I think within this, the concept that we've been looking at and that Luca, I think you all have been working with as leaders, is this concept of sovereignty. So, what are the facilitators here? What do we need in order to innovate? And so, I'm going to finish up on this note. I think we have two big pillars when we speak of AI. First of all, when we think of governance and a responsible use for protecting fundamental rights. And then the other pillar is a complementary one, which has to do with how to support these facilitators, these enablers that you have mentioned so clearly. And I think in this sense, the Brazilian government has worked under the G20 scope, reviewing its AI strategy and thinking about elaborating a national AI plan, which of course should be done thinking more in the short term. And this was a direct demand from President Lula. So I think these two complementary pillars are very important, and they can inform and inspire our regional debates here, specifically at CPDP LatAm. So thank you very much, and I am anxious to hear from Max as well. Excellent. Thank you. So we will pass the floor to our dear Max now. The floor is yours.
Invitation. I already have to kind of tune down expectations slightly. I was generally asked to talk a bit about what we're actually doing in litigation in Europe right now, and then move over into the AI debate. Just to quickly explain what this logo is up here, we're basically a nonprofit organization that right now does enforcement of only the GDPR. So we have not done AI Act, it just now exists. So a lot of the products and a lot of the questions that we have, they're not there in practice. So a lot of what I can talk about is just the first little blinks of this really hitting the courts. We basically do three types of enforcement. It's more like a consumer rights organization. We basically do standard setting cases, which is like big questions like some of these AI questions. Then also pure enforcement cases where companies simply don't comply with the law. And then one big question that is upcoming and maybe interesting here as well is collective redress, because it's typically these violations are a matter for millions of people, but none of the individual person will actually go to court. So how can we get that together and actually enforce things? Just as a background, we do a lot of stuff. Obviously, the data transfer discussions are probably somewhat known about the NSA actually taking a lot of the data in the end to do espionage. But we also do stuff, for example, on credit scoring, which I'm going to get back to a bit as well, because that's stuff where AI is interesting. But we also have very small cases in that sense that, for example, we have a payment provider in Germany that also got all the products you bought, and we had a person that actually bought stuff on a sex store, and then you could see actually each individual dildo she was buying just on a payment provider. So it's stuff like that where like, why does the data actually go there? Similar cases where, for example, Grindr that forwarded the location that you're at to more than 4,000 partners whenever you open the app. So we do a lot of this typical GDPR litigation. PRK is a big thing that is upcoming in Europe, where basically they now charge if you don't consent. That's one of the things that is going around. One very interesting situation that we have is also the use of data for micro-targeting in political advertisement, where political parties give you different opinions depending on what data they have on you, stuff like that. Now, that's just a bit of a background what we do. What I wanted to talk about a bit more is maybe GDPR in reality. We do usually talk about the GDPR and how it's, I don't know, too strong, so strong, and so on. But if you actually litigate that in practice, it's very different. And I think if we do law and also new policy, the big question is how can we actually get the results on the phones of people or on the reality of people and not just in the abstract. We obviously, as an organization, we don't do lobbying, so we litigate thereafter. That's oftentimes much easier than writing the laws. But that's kind of where I think we also have to look at. This is the Irish Data Protection Commissioner, or it used to be the Irish Data Protection Commissioner. This is the office that actually regulated in Europe Microsoft, Google, Twitter, LinkedIn, I think the whole list. And this is a supermarket here. This is actually the regulator. So when we started to actually then enforce the GDPR the first time, I was literally in front of this door physically trying to deliver a lawsuit. They now have a new fancy building and more staff and so on. But we have to think of how is that actually then implemented in practice. At the time, they didn't have a single lawyer, they didn't have a technician. There was no reality that they would actually negotiate with Meta on how to do any of this. And we see that play out now in current situations as well. To give you an idea, you do have a right to complain in the European Union, where you would have a free right to kind of go to an authority and have your case heard. But for example, the Irish regulator handles 99% of the cases, 99.9% of the cases by just throwing them away in reality. So they say the complaint was handled, but then actually nothing happens. And that doesn't help anybody. Like that is not what all this regulation is there for after all. We have situations, especially that because of the independence, the executive oversight of DPAs doesn't really exist. There is almost no legislative oversight. The judiciary, you can go there, but in most countries, it, for example, costs 5,000 euros to appeal that your free complaint wasn't heard. So in reality, your free complaint costs 5,000 euros. In Ireland, that costs about 100,000 euros to have a case like that. So it's just not available for normal people. And that is the situation that we then see on the ground, where on paper you have all these options, but in reality, it doesn't really happen. Even with the penalties that we have, so for example, Meta got in one of our cases, that was the data transfer case, 1.2 billion euro as a fine. These fines were never paid. Like, you may have seen the headlines about the big fines, but hardly ever were they ever paid. They're all still on appeal, paused. They will take 10 years until they're finally paid. So a lot of this is then in reality, if you really try to get a company to comply with any of this, what you're faced with. To give you also an example of where these fines may fail, we have this 4% of the annual revenue as the maximum fine in the EU. In one of the cases we had, this was the maximum fine for Meta. This is roughly the revenue they made in the time by violating the law. So even the maximum fine would have not captured the money that is made by the violation. So there's a lot of these things that we have to rethink if we do new legislation, how that's actually biting and how that actually works. Last but not least, you can oftentimes go to courts with all of that stuff, but our experience, at least in Europe, is that the typical court, the typical judge hears GDPR and privacy and digital and gets a heart attack and just doesn't want to hear about it, because they've never had this law in law school. That's going to be even worse with the AI Act that no one is going to understand in a judge and in a court usually. And then they're terrified of technology. They don't understand how it works. And then as a judge, I have to make a decision over technology that I don't understand. So usually these typical things that we have are quite complicated to actually get anything done. One of the results of that is that we ask now, at the beginning of the year, data protection officers within the companies, so the people that within the companies are in charge of actually getting this law complied with, if an authority would go into an average controller tomorrow, would they find relevant GDPR violations? And 47% of the people say yes. So it's a bit like if you have a security officer that says yes in 47% of the companies, security is just not complied with. So we do have these realities on the ground if you look at how did it change the actual life of people after all. What is an uptick in all of that is what we do see is that the Court of Justice is somewhat permissible for emotional damages, so for non-material damages from the GDPR violations. And that in combination, as I mentioned before, with collective redress could be really interesting. So if you have, let's say, an algorithm where the data of 500 million people was sucked into without a legal basis, and they all ask for 100 euros, that's not much per person. But if you do the multiplication, you have cases that actually could become interesting and could bite. We did have some examples of that where we tried that and actually worked somewhat, but you need a lot of good technology to actually run that. So we ourselves basically build software to run things like that. Now, to actually dive over into the AI topic that we would continue to talk about. So far, what we see in AI is that we have, last year it came up as a topic more, but we hardly saw it in consumer products. We're now starting to see that in actual complaints that come to us, where an average consumer that is not at the conference talking about fancy new technology, but the average person on the street actually sends us complaints on these things. We first saw that as one of the new trends that we actually take more seriously. There is a lot of trends in technology, and we talked about blockchain 2 years ago, and I don't know, Google Glasses when I started with this. This is the first one that we actually take seriously because we see that that's going to be used in practice and probably there to stay. We see the huge potential in it. So for us, it's really not to block it, but how to get it right in the current framework. And that's more what the thinking is right now. So we have two cases so far, one on OpenAI, the other one on Meta AI. The Meta AI case may be very known here because you had a very similar case just in Brazil as well. The topics that we look into under the GDPR right now only is, first of all, in the data gathering phase. So when you actually get all that information, the sources and the legal basis. Usually what we saw in the first two cases where we saw that the companies have huge problems with compliance is to separate that personal data. So typically they say, for example, how to separate personal and non-personal data, but also that they oftentimes say, oh, we're trying to get outside of the European Union application of European Union law by just saying, oh, we don't use EU data. In practice, we know, however, that usually that data is so connected in their systems that it's almost impossible to separate. So a lot of this, like how do we get clean data that we can actually use legally, is one of the things where we couldn't really get satisfactory answers so far. Same topic, especially under the GDPR with special category data. So how do you separate data that reveals sexual orientation, for example, from other data that you have in the same data pool? Big question was usually the legal basis that we need. So I do think that for most of the direct gathering of data, consent or necessary for contract could be a legal basis. But a lot of the companies don't really want to do that. I get to that. There is the option, obviously, to have non-personal data sets where the whole law doesn't even apply. But where we see now the first cases coming up is in mixed data cases. So the first one that was actually up there was OpenAI, where there was a question, how much do you have a legal basis when you actually don't want to have personal data, but it's just in the data mix. There is a bit of a tendency in the first papers that come out of the regulators to say it's a bit like Google when they basically just scan the whole internet for search results. They cannot really make sure that there is no personal information in there, so that there could be some way for a legitimate interest to do that. The secondary use of data was quite interesting for us. That is more the Meta AI case that we had, where it's purely personal data. Basically, the whole social network is full of personal data, and that is then used for the data gathering here that may not really have the legal basis. One thing I was personally wondering about is that they hardly use the research exemptions that are in the law. So the GDPR foresees a lot of options for research. That's actually done by the member state. Each member state can have research exemptions. That's so far not really argued by these companies. If I would be their lawyer, I would probably look into that more. But so far, that's not really what they do. One last bit that on the data gathering part is interesting is this whole idea of purpose limitation. We usually share data for a specific purpose, and now it's then used for anything. Especially with Meta, it was really interesting because they said that AI is basically the purpose. So it's like the purpose of processing the data is computers. It's like it names a technology as the purpose. That's how they try to get around that, but that's not really how the law would foresee that. There is actually a pending case also on published information. That's a case that we are running right now at the Court of Justice, that also in published information, you usually have a purpose why you publish information, and can you then use it for something else and not really have that limitation. So on the data scraping part, I think that's going to be a tricky one and going to be something that we'll discuss a bit more. Obviously, there is the option to use open data or data that doesn't have these protections, but there's limitations, and I guess other people in the room know much more on how much that's then really useful. On all of that, what we now see politically, what happens out of that, and Meta just basically announced that, I think 1 or 2 days ago, that they basically now say, if you have these rules, we're not going to provide all our products in the country, full stop. So we see kind of the reaction from the industry to be more or less collective punishment, to say, if you want to have any rules, then we just cut you off from any new technology. And that's quite interesting in the dynamics of how we really regulate all of that. If you look into this article a bit closer, for example, they basically now say that there's the showdown, and it's basically their argument is that it would be unpredictable how the European regulation would work out. It's actually not that unpredictable. They went to the Irish regulator and said, can we do it? As always, the Irish said yes, because they just don't regulate big tech. And then the rest of Europe said no. So the unpredictability is somehow limited. In reality, it's more that they just didn't want to hear the answer. What was an argument that came up is, for example, and I heard the argument at the conference as well, is that they need all this data to reflect the culture of the region. So it now basically says, unless you give us all your data, it's not going to be personalized for you. A lot of that, however, you could also do with opt-in consent. You could just get 10 or 20% of a society to say, yes, I actually want to have my data be used for that. And that would still be enough to personalize or to regionalize information, probably. As you can see, they themselves actually say that Google and OpenAI are doing that because they're a bit more open to that. What's also interesting is they tried, for example, not to get consent for any of this, but only did an opt-out option, which they basically said it's legitimate interest and you have an opt-out. And that was done so complicated that you had to even fill out the reasons why you personally feel affected. All of that was never reviewed. If you filled it out in 1 second, you got the approval, so no one has ever read any of that. It's just to make it as complicated as possible for people to really have their data not in the system. Then next, there is usually the whole transparency debate. A general note, we usually don't look into transparency all too much, because the reality for the average user is you get a shitload of paper that no one reads anyways. So a lot of the transparency calls is an easy way to say we did something, but we actually didn't change the product. So On transparency, we're usually sometimes a bit questioning how much it gets us anywhere, but the typical right for transparency is the right to access. So we went through that with OpenAI actually, and asked for the typical data that you get under the GDPR. The short answer was, can we have it? Answer no. The long version of this exchange, you'll have a problem in my PowerPoint, I see. That's the long answer. So we got an email back where they basically said, we're going to keep all that data, and the only thing we can do is that we block that information. There was never any access to the data. Where does the data come from? Any of that was never anything we really got from OpenAI. Next problem, once you get the data, is then the accuracy question, especially if it's on individualized on individual people. So we do know all these wonderful examples of what AI can tell you if you ask it questions. And I have to say, accuracy is also a problem in practice. So in existing technology that we have, it's not new necessarily for AI that you get weird answers. We do have credit scoring, for example, where we know they're oftentimes lousily bad. So one of the big credit scoring companies in Austria, I asked for my own data, and I'm in that whole data set of 100 people, one of the people with the highest credit score. When I was 19 years old, working for the ambulance instead of going to the military, where I got like 300 euros a month. That's one of the highest rankings, and one of the lowest, or one of the kind of rather a bit lower, is the richest man in Austria. So a lot of even these old technologies didn't really provide accurate data, but with AI, this is something that we're looking into a bit more. So we typically have this requirement if it comes to personal data, that data has to be accurate, and that every reasonable step, so you have some wiggle room here, having regard to the purpose, must be done to rectify or erase data if it's not accurate. So that's going to be quite a challenge if you do that. Under Article 16, you also have the option to then rectify the data without these caveats. So if someone walks up, you actually have to rectify whatever comes out of the system. You also have a duty to complete stuff. So if it's not fully there and you need additional information to give more context, you would have to kind of squeeze that into the system somehow. There is additional elements that you also need to notify any of the recipients. How you put that in practice is going to be interesting. And most interestingly, I think in litigation, you also have the non-material damages. So if you basically say, there was wrong data processed about me, there is some consequence, I can actually ask for damages there. If we did that with OpenAI, they basically said they can only block all the data, but they cannot do anything with the data. They can just basically block the whole output, but that's the only thing they can do. So all these intervention rights you should usually have in reality are not there, at least in the systems as we have them. What they basically said, they don't know where the training data comes from. They don't really know what's in the system itself. The only thing they can really do is to have a filter, but that's a yes-no filter, so it cannot alter the output. It can just block the output. And that's then in the end what you see on the phone. So it was kind of interesting that a lot of these theoretical rights we should have, where you should have options all along the way of this chain, in reality, they say they can't really do. Now, last but not least, is any of that really new? I have the luck of working in privacy for, I think, 15 years by now. And we saw with every new technology that this is all not doable, the law has to be changed and so on. And ever then we have basically the sticker saying breaking the law is not innovative. So with every new innovation, the law is usually not complied with in this space as far as we can see it. The big question is how we can alter the law, partly because this technology may need some alternations and some adaptation. And for example, in the AI Act, there are some examples that do that. But then I think for us especially, it's interesting if we have a democratic choice, like having these rules, for example, how do we actually make sure that that's enforced in the end, and how big companies actually comply with that? One reason why they may not be all too interested in complying with that is this chart. This is basically how much is Meta making per user per geographic region. In the US, that's last quarter, it's basically $70 per user. In Europe, that's a third of that. So they may just not have overly too much interest to really deal with all of that. And if you then go for the rest of the world, that's a whole different number. So there is also a lot of economic reasons why you want to comply with that or not, which may be quite interesting in the setup here as well. So I hope that was somehow useful in what we're doing right now and can help to start off the conversation.
Muitíssimo obrigada.
Thank you very much, Max, for the excellent explanation. I think you brought interesting points as classic principles of data protection as transparency, right to access, quality of data, accuracy, and they were always difficult to apply principles. And this compliance and this application is even more complex nowadays. It's really interesting. Congratulations on your work. It's really interesting for us here in Brazil as well as a region. It is interesting and inspiring. So without further ado, I want to pass the floor to our speaker, Nikki Pava. Nikki Pava is the founder of Medianama. And the first question, Nikki, to you is based on the Indian experience. How do you think G20, if they can change digital policies, and how G20 can promote a positive agenda on AI? And on what extent the Indian policy of digital public infrastructure can inspire the policies here in the region? Thank you, and you have the floor.
I'll just take this off. So the framework that I would like you to think about is don't do what India does, in a sense, right? And we take learnings from how India approaches data. So if you think of that flawed philosophy of data as the new oil, India as a country truly believes in that idea. And so if you thought of data as the new oil, what would you do? You would collect as much of it as possible. You would protect as much of it as possible, in the sense, don't allow it to go overseas. And you would try to control it, and you would try to monetize it as much as possible. So India embodies right now an approach to governance that says that government as a service, so it thinks like a platform. It thinks of data as a processing of data, uses of data, just like a big tech platform would. And so it focuses on collecting as much as possible. The idea behind Aadhaar, our national ID, was to have a single identity, to have a 360-degree surveillance, 360-degree data about each individual to better provide services. And so, India also believes that data is a mechanism for it to become an AI superpower. Nandan Nilekani, who is primarily the architect of a lot of our digital public infrastructure, he's the biggest cheerleader of it, has gone on record to say that before India becomes economically rich, it will become data rich. And we are already data rich, and that's why all the digital public infrastructure has been rolled out to enable that. Now, if you go back to, and as Luca had mentioned in the opening remarks, why how India got the fundamental right to privacy is because in order to protect our digital ID and the data collection and the linkages that were happening, they went to court arguing that privacy is not a fundamental right. And the government of India lost that case, and the Supreme Court declared it as a fundamental right and said that there should be a data protection bill. That data protection bill took 6 years to create, and it passed last year and has still not been enforced. It completely exempts our government, and it also incorporates an interesting idea of a consent manager, which at one level enables citizens to control where the data is shared and how it's shared, but also it makes consent extremely easy. So we have a joke about digital public infrastructure service in India, is that in India, consent is voluntary, but it's mandatory. In the sense, denial of service is a mechanism to make sure that you give your data. How that data gets collected and gets shared, beyond a point the government has no control. The people who run the infrastructure have no control. And consent, instead of increasing friction for consent is reduced. The idea behind that is that India is underinsured, it is undercredited, and so the more data that's available, it makes insurance companies and banks, it makes them easier to essentially understand citizens better and lowers their cost of failure of providing insurance and credit. And so the idea is to profile the citizens in as much detail as possible. looking at both. So there are IDs for education, IDs for health. Your driver license is connected. Your RFID chips on your cars are connected to your driving license, which is also connected to your national ID. So the silos that exist in government and in services between databases are broken through the digital public infrastructure system that exists. The other thing that happens in this entire mechanism is that the digital public infrastructure, except for Aadhaar, is created as private entities. They're private, non-profit companies, and so they don't fall under our right to information or freedom of information regulation. So they're not accountable, because we filed a right to information request about facial scans getting done at the airports. And we were told the government has no information, the Ministry of Civil Aviation has no information, simply because these are private companies. And so while it's good to talk about accessibility of services, UPI is a huge success. There is digitization of payments, but there's also tracking and surveillance of citizens taking place with no accountability for who gains access to that data. And one of the stories that you should read about coming out of India over the last 3 or 4 years now, and it's scaled up rapidly, is the amount of fraud that is taking place. And a large part of this is owed to the kind of data that gets collected, the data that gets shared. I got a fraud call about, I would say, 1 week ago. Went on for 30 minutes. Very sophisticated social engineering scam, but they had my details. They knew my mobile number, my name. They knew which bank I was banking with. Where is that information coming from? From the digitization and easy sharing of information that takes place in India today. So, digital public infrastructure is built to enable data flows. And it's basically built to reduce friction in transactions and reduce friction in data sharing. If I had to give lessons that G20 needs to take, and remember, all of this data sharing is meant to enable AI, which is why India is not looking at they're looking at a light touch regulation of AI, because historically, even with the first data protection bill that came out, with the data protection report that came out, the philosophy was economic growth versus data protection. So privacy is seen as a deterrent to economic growth. What we hear often in India is that let's not make the mistakes that the EU is making. And an open economy and an economy that allows the free flow of data will grow faster. And that's how India will become an AI superpower. But if I have to say about what one should do in order to ensure that you do your digital public infrastructure right, I would say firstly, make usage of digital public infrastructure and data sharing optional. Secondly, increase the friction that is required for making transactions, because it is the reduction of friction in data sharing. It's a reduction of control in data sharing that leads to this proliferation of data that becomes a financial risk for individuals. Create silos between data sets and IDs. What's happening is the moment you link everything to a single ID, that becomes a single point of failure and has been proven time and again. Give the right to revoke IDs, give the right to revoke data sharing, but also give the right to change your ID if you need to. Allow IDs to even deprecate over time, so that if the data does leak, it doesn't persist over time. Allow options. So what you'll see with the so-called digital public infrastructure is that these are oligopolies that are getting replaced with monopolies. So UPI is effectively, for digital payments, is a monopoly. But even on top of that monopoly, it tried to replace a duopoly of MasterCard and Visa. But on top of that, there's now a monopoly of Google Pay and PhonePe. And PhonePe is largely owned by Walmart. So you're trying to break monopolies in markets, but you're creating new monopolies, new oligopolies at the same time. Digital markets will always consolidate. That's a reality that we've seen over the years. And there is not a single instance where there hasn't become a monopoly with the usage of digital public infrastructure. create accountability mechanisms. Almost all digital public infrastructures in India are not accountable to the public because they're not public platforms. They're not owned by the government, but they're controlled by the government. It's a very bizarre structure that exists. I would say that there should also be purpose limitation for the data that gets shared. Without a Data Protection Act, we don't have that. And lastly, avoid the usage of biometrics in all of this. Biometrics has been forced upon us because of the ease of transaction that biometrics bring with it, but it's also led to the disenfranchisement of many people who don't have fingerprints. People who labor that works, let's say in carpentry or in agriculture, they don't have fingerprints because it's rough work. They get disenfranchised. There are old people whose fingerprints change. They get disenfranchised. And I always say that biometrics are a permanent username and password. And it's easy to, someone taking a photo over here can easily take my facial data and build something, right? So if you want to avoid the mistakes that India has made, avoid biometrics. Thanks.
Muito bom, eu gostei muito.
Excellent. I really like that. I always like listening to you because what you say really allows us to think about things in a more critical way, I think. You know, sometimes these things are presented as miraculous solutions, but they have a more negative side that has to be considered. And I think the narrative we have is about the massive use of data as fuel, let's say, for AI. And we can see this is a global phenomenon. And here we have our friend Stella Hania with us once again, that represents Brazil in the UN agency about AI, which was created at the end of last year, and who is thinking about how we can create governance systems that are global so we can try in some way to manage the evolution of AI. So Stella, the floor is yours. Good afternoon, everybody. First of all, just very quickly, I want to congratulate you for organizing this event. I think it is the main event in Brazil for data protection, and now we are having so many discussions about AI. So congratulations, Luca. I'm really happy to be here participating in all of these debates. I think we're very lucky. Congratulations to the team. Yes, to the whole team. It's quite a privilege, and you know, I think it's one of the few spaces in Brazil in which we can have a wider international discussion, especially looking at the global South and Latin America, because usually we look at the US and Europe, and you know, it's good to look at the South and think about the BRICS, and I think FGV really contributes to this discussion, so I want to congratulate you on this initiative as well. So I'm going to speak about the high-level consultancy committee of the UN on AI. I am a member of this AI advisory board. And as you just said, there are no miracles here, and that is the problem. So if we look at technology as this magical solution that's going to solve problems, well, it's not that. It's an instrument that can be used or not, depending on the situation and the paths that we build for these technologies. Then we have the possibility or the need to use this technology for the common good. And this means that we need to reflect on this while we are building it. So I am just going to explain quickly what this advisory body is. It is in the General Secretariat of the UN, and it helps the General Secretariat directly, Antonio Gutierrez. We have had many meetings with him in person, and he is very interested in this. We had about 8 meetings in person with him speaking about this. I think that's a very important sign that this is a very important topic today. So we're analyzing and debating the recommendations of international governance for the UN. Specifically this year, we have a process which is the Global Digital Compact every year. In the UN General Assembly, we discuss one topic specifically. And we will also be having the Summit of the Future, which is a high-level governmental event with global leaders. This year, the discussion is going to be about the Global Digital Compact, that covers several digital discussions about the integrity of information, public infrastructure. AI, of course, is one of them. And the idea is that the final report, which will be delivered in August, should also be a part of these debates and the results that will come out of the UN. So this is our council. These are the members of the AI advisory body, 39 members from different regions. We have gender equity. Actually, we have a few more women here in this group. So people from the private sector, civil society, industry, government, academia. And we organize several regional, in-person, online events, deep dives, discussions with specialists, discussions with all of the UAN agencies that are involved with this topic. So we could have more perspectives included on this. And the idea is that this group is not only thinking about the governance for AI today, but we're looking at governance institutions in this environment with the speed of changes and, of course, looking at the development of new technologies. It's always important for us to highlight that this work does not happen we're not working by ourselves. We're involved with human rights, legislations, all of these different aspects that are applied to AI. So we're thinking about peace and security, sustainable development as well, thinking about opportunities and protection, risks. So the idea here is really a general coordination of the whole UN system, thinking about the compliance with international legislation and how we work with global governance. So this sense of urgency, I think, is shared amongst various organizations considering AI in different regions in the EU. We have the several events, G7, G20, etc., that are also involved in working in relation to this. But what happens is that in these processes, many times the Global South is not included in discussions. And when the Global South is in these processes, the Global South is a guest and not in the decision making directly. So considering the process that started in London about safety, that then went to Korea, then France, there are some countries that are, of course, more involved, like India, which is heavily involved in AI, Korea. But when we speak about this Global South or the global majority, we are quite absent from these discussions. And I'm going to speak about this more shortly. We have an interim report that we launched in December of 2023 that has preliminary conclusions for this debate. And from these conclusions, then we started another debate round in which we had many conversations about this and we brought forward our proposals. It's very interesting material if you want to take a look at it. First of all, we look at the opportunities, the members, the enablers that will help us to use the possible benefits of AI. Then we speak about risks and challenges of AI that we will be seeing in the near future, and then several discussions thinking about a deficit in the global governance, and we need new institutional arrangements in order to deal with the current moment. And now, what is the role that the UN has in this deficit? So I just want to highlight that I was the co-chair of this risks and challenges group with Virginia. So I just want to speak a little bit more about this very quickly, because in many of the debates that I go to, it seems like the UN is discussing existential risks or big wars. And it's not about that. Of course, the arms race is of concern, but that is a concern of the Security Council. And okay, yes, of course, we talk about this, but it's not our main role. Our main concern here has to do with these races to the bottom. So when we create such huge competition that we abandon any aspects regarding security and rights just to be able to achieve this development. And of course, this has severe consequences when we don't look at risks and possible side effects and when we don't notify the problems, etc. So there are other risks as well, of course, from these big risks that we thought about. We're thinking about responses to international incidents. And we are also looking a lot now at the use, well, first of all, how the tool was built, right? And how it is being used and what we can perceive in this sense. So we're discussing all of these aspects, from those that are more well known, like the biases, the business model that is based on monitoring or vigilance, which is a problem, and more recent problems that have to do with trust. And then we have the generative AI debate as well, several speculations about this, right? They call this hallucinations, or these several speculations on the linguistic models, disinformation, and now the environmental issue regarding energy consumption, which today presents itself as absolutely unsustainable in these models. They are not sustainable at all. And we're speaking about sustainability in terms of the environment, but also economic sustainability. And we need to think about interoperability and other aspects regarding the benefits. Now, about the arguments that want to favor global governance, what are the convincing ones? Well, we're speaking about the raw material for AI that involve, for example, critical minerals, the labor behind this whole chain, how this is implemented cross borders, what consequences this has for everyone, and this accelerated development of AI will be concentrating power and wealth in specific areas of the world. It has important geopolitical implications. We still don't have enough understanding about the internal functioning of AI in order to control its results or foresee its evolution. And we need to consider its possible negative consequences globally, how this can affect us. And obviously, the development, implementation of the technology cannot simply be in the hands of the market. We need to be involved in this debate, thinking about the nature of this technology itself, which it works internationally and is used in that way. And therefore, we need to approach it globally. And the governance is also an enabler here for innovation, and especially so that these benefits can be spread out in a more equitable way globally. If we don't work on this in some way, it will continue being concentrated in the global north, and the development opportunities will not be shared. So this is also an issue. And here, our report, something that's interesting is that in our preliminary report, we work with guiding principles.
And the idea is that the member states will commit to these principles established, and we talk about the necessity to include the benefits to everyone, public interest, to be in tune with the data governance and the promotion of data commons and not only personal data. The governance must be universal, networked, and rooted in adaptive multi-stakeholder collaboration and anchored in the UN Charter and all these sustainable development issues. And for that, there are some governance issues, governance functions that we need somehow to discuss and establish in global governance, and we recommend that these functions that are established here, I won't have time to go into them in details, and this is what we talked about. There are many different initiatives of global governance, but these initiatives, only 7 states make part of all of them or coordinate them. That's most of the global south. It's outside of that. So we need a lot of guides and principles and instruments adopted, but most of the world is not represented in participating here. So among all the recommendations, just to conclude, the main points of action that this group proposes is the creation. In the beginning, we talked about a global entity to provide governance, but we know that the multipolar world is under crisis. And we reduced the ambitions a little bit. So we are talking about a scientific board, about AI, to build common understandings and interoperable governance approach with the participation of all the countries and a global dialogue to create a better structure or an AI agency and development of these regional and local capacities, especially from the global south. And the idea of a global fund for the development of sustainable AI and a redevelopment of these capacities, a global forum of harmonization of AI standards, that we have many standards and each one is done in a different way. Data structure of AI. And lastly, an office inside the General Secretary of the UN to coordinate all these initiatives. So then we can continue the debate. Thank you, Stella. I think what you said is very important, and you show how the global challenges needs to be followed by global strategies. And we have to think, as more complex and challenging that it might sound, we need to think about global governance. And with that, I want to pass the floor to one more speaker, Griffith Cadena, who is professor of the Rosario's University in Colombia. And we want to know, Professor, we know that AI demands a data extraction, an intensive personal data extraction, and the Data Protection Authority, how can they find some type of balance between individual rights and fundamental rights and at the same time thinking about innovation and fostering? Please, you have the floor. Thank you. Thank you very much for the invitation, Professor Luca, that was kind enough to invite me to this space. The question is, well, the question that the regulatory agencies ask every day, especially Data Protection Authority from Colombia, that is from the trade uh, institution. I'm giving a context to you. Unlike many other data authority that are guided only to be data protection and privacy mechanisms or freedom, the superintendent of the industry and trade in Colombia groups four different activities. One is the data activity, the right to competition, the right to consumption, and the right of intellectual property and brands and patents. So it is a macro structure that forces us necessarily to think in a transversal manner. So of course, we are joined by the word regulation. But the word regulation can bring different meanings. We can see regulation as a limitation of the market. Some people can see regulation as an enhancement of this market. In economic theory, the regulatory idea is based on reestablishing the market conditions. So the competitive market, a market that allows a diversity of actors. And this is the nature, this is the regulatory meaning that we adopted in our superintendence. Regulate to create conditions for a competitive market. But conditions for a competitive market that are inside these dynamics of constitutional ends, as all the democracies do. And one of these constitutional ends in Colombia is the habeas data, that is a fundamental right. This generates a normative framework, that is a law that governs that data protection regulation in Colombia. So when Luca asked me, How do we build this balance between the market and data protection? This is a question that the Colombian authority does not decide to choose between one thing and the other. Of course, that you need to guarantee the conditions of the market. The market is also a constitutional end in Colombia. Our Article 233 says that our market is a mechanism to offer goods and services. This is the reality. And it is also a mechanism of economic democracy, etc. And there's also the dynamic of the data on the other hand. The answer touches many points, and one of these points is the issue of consent. If you are the data owner, the person who owns the data, how can this person exercise this relationship that can be a contractual relationship facing those who decides to treat the data? Is there a consent? Is there a clarity on the purposes of all that? Or is the citizen aware of that or not? And this is the legal discussion. There might be many different answers. One is to treat the citizens as an underage. The state protects. This is the traditional vision. And maybe this is the vision that we adopt. But there are other alternatives. We have the idea to empower the citizens, to treat them as the same. From the treatments of the data, the citizen is going to decide what to do or not to do with this dynamic. And this is a dynamic that can happen possibly from the contractual rights and the equity of this data. And it is a discussion on how to exercise this dynamic of equity. And why am I saying that? Because in Colombia, we are discussing the reform of the Data Act. And that promotes many different discussions that emerged from different professors. So let's say, in order to keep this tension and this balance, an element that I think it is key is the issue on the exercise of the consent, how the citizen is aware of what is being done with their data. To us in the superintendence, it was critical to build a proposal of an authorization for these treatments that can be previous, expressed, free, specific, informed, and unequivocal, because the citizen needs to know. And we also put the necessity that there is a knowledge of the citizen. The citizen needs to be informed, and who is going to treat the data needs to inform the citizen about this use of his data. We were saying in the panel about digital platforms here, and one of the practices that we see the most in the superintendence is the use of data without informing the citizen. For example, e-commerce platforms or food delivery platforms without the citizen knowing what is being done with their data for advertising or for discrimination of consumers, or even simply, as it was mentioned here by the professor, to restrict the access to other competitors in the market. So this is an essential issue that we deal there. But the authority also faces the issue of the nature of the digital markets, especially about AI. That is the principle of uncertainty that is followed by the innovation. Under a rule that was imposed, that is the rule to build legal vacuums, meaning in the breaches of the law, they create new business. A classic example of that in some years ago, we knew that the authority didn't have a structured response for that. And today, the challenge that we face is the identity. Everything that has to do with a business model that is not very clear. We collect information, but we don't know what business model is behind that. So how do we respond to these phenomena? Of course, if the rule that the market imposes is the rule of innovation from the breaks of the law, the legal response, the response of the authority needs to be the legal innovation. The legal innovation that invites us to produce innovation from reconceptualizing the legal concepts. So we have two classic tools on the public law. One is the principle of proportionality and the precaution. Proportionality from criteria of reasonability, understanding the ends that you are going to act upon, and the authorities are going to use the principle of responsibility demonstrated, because they create a criteria of responsibility of those who administer the data if this person needs to demonstrate the good use of the data. And it is an inversion of burden. So that makes it even more difficult, the assessment of the impact for the market. And the principle of proportionality, especially regarding generative AI or artificial intelligence that is guided by those who have the risk, is the human being. And it is the principle of proportionality, the principle of precaution. In terms of artificial intelligence, it is key as they allow the authority to generate a prevention of the risk, in which not all the rules of the markets are going to be valid. And because it is necessary, something that we need to implement is that impact, the impact studies facing new technologies in which the uncertainty is the rule. The impacts on fundamental rights are uncertain. Is that in these logics of the principle of precaution, the logics of the abstention, unless you, with impact studies, you can demonstrate that there is an exercise of moderate risk. Of course, these two dynamics, if we think about the logics of the market players, especially the big companies, they can be classified as anti-innovation. But if we think about the logics of a competitive market in general, we consider that they generate market metrics, especially in a fundamental thing here. There are the logics of the new technologies, especially the artificial intelligence companies, are logics of monopolies or oligopolies. But when they are considered these type of logics, the first sacrificed is the market, and the first one is to be sacrificed is the innovation. The innovation will implicitly disappear. So these rules, if at one side they try to protect the citizen as a constitutional purpose, on the other hand, they generate a dynamic of market symmetry, a competitive symmetry, to be developed new technologies, especially having new technologies that are important. There are new technologies that implicitly, by definition, they are oriented to guarantee the fundamental rights. This is an exercise of the best practices. And I would close with something. Something that the private sector likes is ranking. Dynamics in education, the best university, the best lawyers, everything is the best. And we created our ranking from the markets of sanctions that we are having, because we also have companies that are complying with our law that has low levels of sanction and exercise more investments in the protection of rights.
So then, actually, in a few weeks, we will have our first ranking in Colombia of public and private companies that are able to better protect data, and which ones have a higher level of risk and which ones have received more sanctions by the administrative Colombian police, so that we can be able to impose these important sanctions to these tech companies, which we know is not exactly the economic sanctions. We know the issue here is the reputation of the sector. The conscious citizen needs to know when they are dealing with a company that deserves their trust and when they deal with their data, and a company that generates a very high level of risk with their data. So this is what we are trying to adapt. We're not trying to fight against the market. We want to have a competitive market. Excellent. I also wanted to say that we also like these different rankings as well. We're conducting investigations on compliance in different sectors to have this ranking because I think it can stimulate to have more efficient compliance, right? And yeah, it is a little bit of naming and shaming, you know? Nobody wants to be in last place. Everybody wants to be in first place. So let's use the data we're producing. Something else I want to highlight is that I think the Colombian model, you know, we're always looking at Europe or the US, and we don't look very much at our neighbors. The Colombian model, the institutional Colombian model, the superintendency for trade and industry, a regulator that combines a data regulator, an intellectual activity regulator, trade in one jurisdiction, it really is a huge advancement in terms of a capacity to regulate AI. Because every time in these other countries we see the creation of a new law, then we want to create a new regulator. It takes 10 years, then another 10 years for it to be effective. And then maybe in 2050, we're able to regulate generative AI. And that's not going to be very efficient, right? So I think we need to rethink this structure of the authorities, of the regulatory authorities. It should be an idea that we should reflect on. Speaking of authorities, I will pass the floor here to my dear friend Jonathan Mendoza, Secretary of Data Protection at INAI in Mexico, to share with us some of the challenges that you are all facing in terms of regulating AI, specifically in data transfers. Please, Jonathan, the floor is yours. Thank you so much, Luca. It's an honor to be here at CPDP LatAm for the 4th year in a row. And I'm reflecting on everything I've heard so far. I think I've restructured what I wanted to say because I want to share something useful with you all. The new way to understand information self-determination is through algorithmic transparency. To speak about the control or protection of personal data, you know, that's kind of out of vogue right now. We speak of governance for data protection or governance of AI today. So how do we think of informative self-determination conceptually? You know, how should the control of our data work? The control that does not work in practice, right? If we understand the digital ecosystems, we all leave some tracks behind. There is profiling. Perhaps algorithmic transparency could contribute to this so we could make more informed decisions. I don't know, maybe. I'm just sharing this with you all because it's a bit about adapting the regulations that are still static to this reality that is increasingly dynamic with technology and innovation, and that is not going to stop. And when we were speaking about standards and personal data, and we need to think about globalization, right? This does not work with jurisdictions that are only applied to one country because they're not enough. These regulations are simply not enough. And they should, in theory, be following technological neutrality. When we speak about personal data, are we speaking about human rights? Yes or no? Everybody is going to have a different answer depending on the country they're from, because it's not in every country that the protection of personal data is considered a human right. So the data from a citizen from the EU, is this data better than the data of a citizen from a Latin American country, or do they deserve higher protection? The answer is no. This has to do with the current regulatory frameworks that exist globally. So we have territorial solutions according to the country, regional solutions for global issues. So what should we seek out in an ideal world? And, you know, elaborating this has demanded many years. We need to find a normative equivalency so we can find an adequate standard for protection. Because if we're looking at disruptive technologies and privacy, this is a Molotov cocktail we have here. So sometimes we're making this false choice between technology and privacy, right? So to use this technology, I'm sacrificing my privacy. We're not conscious about what this means when we give our information. And, how far do we want to go here? How can we find this normative convergence globally? What are the solutions? You've spoken about the GDPR here, about the AI Act. These European norms, they have worked in their implementation. Okay, so should other countries take on the identity of these norms and try to adjust them into their legal systems, considering their political, economic, social, and cultural situations that are totally different? How useful are the interoperability mechanisms that exist today? Because we can speak about clauses in contracts from the Ibero-American Network or the Consulting Committee 108, the APIC system, and several other mechanisms for certification. We see one from the American government, etc. There are many alternatives. Are they useful or not? I'm not speaking about them being useful on paper. This clause that automatically guarantees protection. That's not accountability, right? This is a document, and that can be put into a drawer and that's it. How can we implement these norms in an adequate way? I believe that we need to start thinking about regional solutions because this issue is not the same around the world. I think in Asia, they prefer to sacrifice their privacy more than they do in Europe, for example. So Latin America needs to think about this for itself, and we have been mentioning this. We need to build a model in our region that can be comparable with those of other regions and that can allow us to eventually advance in what we are all seeking out, a standard for protection, because we are speaking about fundamental rights and freedoms, while at the same time supporting technology and innovation while protecting our rights. Thank you very much, Luca. Jonathan, I think you have raised a point that is very important to our data protection community, this self-determination and consent issue, which I think is quite classic, actually, but I think is more and more relevant in this very current debate that has to do with AI. So, we speak about consent and that this should not be something merely fictional. How can we really achieve a material self-determination and not something that is simply formal? I think that is very relevant today. And I think you've made us reflect on something very interesting here. We need to think about concrete challenges that are regional, right? Even the issue of security. Of course, that has to do with different challenges and perspectives and different answers to these problems. So it was a very interesting point that you shared with us. Thank you so much. And without further ado, I want to pass the floor to our dear Caitlin Mulholland, who is a professor and director of the law school here. And Caitlin, we have spoken about self-determination a lot, and you work with another very relevant aspect here when we speak about fundamental rights and data protection, which is the aspect of discrimination. So we wanted you to address this topic a little bit. Discrimination, equality, how do we address this huge challenge in relation to the AI system? The floor is yours. Thank you, Laura. Good evening. I think it's good evening already. Good evening, everybody. Thank you for the question, and thank you once again, Luca, for the opportunity, for giving me the opportunity to participate in such a qualified panel. It was wonderful to hear from you, Max. Max, you are my personal hero, I have to say, after, hearing you talk about your work. I think you're the personal hero of many people here. You are an example that I think we should follow in our country and around the world, really. And I think I'm speaking on behalf of everybody or most people who are present here today. Now, still actually within data protection, but going a little bit more into AI, I think that the big answer, I don't know if it's the big answer, but maybe an attempt at a big answer to deal with discriminatory biases from algorithms, which is something that has been spoken about a lot and more, I would say. I think there are two ways in which we can look at this. First of all, we need to consider the math behind it, and then we need to consider the data. The math in the sense that if we are speaking about AI systems, that, because they are systems and programs, softwares, they are developed by machines, let's say, quote unquote, by math. All of that, which people who studied social sciences don't understand. We need to think that these machines interact with human beings. So, we're looking at different AI systems. We're looking at what maybe Elon Musk is going to do in the future. But right now, we don't have AI systems that can conduct self-management or self-generation. So a human being needs to be involved. So for us to have a programming capacity that considers equality, we need to think about the people that are interacting with the machines, and for these people to be diverse, and for them to bring to the table a capacity to perceive the world in other ways. So this is a first way to criticize this. Yes, it's improving, but when we look at a room with programmers regulating an AI system around the world, usually we have people that are within the cultural standard of that location. So for in the Americas, right, I'm speaking about Latin America here, the people that are participating in these hard sciences are white men between 20 and 40 years old that studied at universities and elite schools, or maybe public universities, but high-level ones, and that have a more restricted worldview. So their work, even though it is very technical, systematized, mathematical, within a standard which in theory is a standard that is distant from any kind of interference from other sciences, it brings to the table a very limited view on the world. So the first way in which we can deal with the algorithmic bias is to have this interaction between human and machine, the man, not the man who is behind the machine, the human being who is behind the machine, for this interaction to be as diverse as possible. And as a society, then we need to stimulate having data scientists, programs, mathematicians, data engineers that come from diverse backgrounds. There are initiatives for this. I'm not going to get into details about all of the organizations, but there are very interesting organizations for capacity building for women, for Black women, women from the city outskirts, so that they can be acting in these hard sciences, bringing in their different perspectives.
And it matters when they program that. So this is the first issue that we have as society to evaluate. The second thing that I think that it can be even simple, both are difficult, but this is simpler. That is the creation of databases that are in fact representative of a reality. Meaning that the people who are going to use the data, I'm going to talk about personal data here because of course we are in this forum here. The people who make the programming, if we think that artificial intelligence work with two inputs, math and data, this database needs to be conformed not only by the objective that you intend to reach with that programming, but mainly with the portraying of a social reality. There are many examples, but if we think two easy examples here and meaningful examples. If you think about facial recognition systems with biometry, we know that there are databases that in an eternal looping that has the capacity of recognition and identification of black men or dark-skinned men, if you're talking about law enforcement, much more discriminatory than other systems. The same way artificial intelligence systems that are used to health or to analyze images for certain types of disease, we already know that there were many mistakes being recognized when they were facing the verification or the evaluation of prediction of diseases when the patients are black women. So how do we deal with that? And I'm swear I'm concluding. And how do we deal with that through the risk assessments in terms of right to equality with a concrete application of the non-discriminatory policy that is already recognized in our Constitution? We don't need a general regulation to talk about the principle of non-discrimination. We don't need a regulatory framework of artificial intelligence talking about non-discrimination, but we already have it. But our federal constitution already brings to us a path. And this path is going to be traveled with the implementation of AI systems that have this discriminatory capacity, the evaluation before, during, and after the development of the implementation. But in order to do that, we need to be careful with the formation of the database, but also the training of people who are going to use these systems and apply and find purposes in the use of these systems. These are just initial ideas. I don't know if you have the possibility of having a debate about this, but these are just initial ideas to talk about these functionalities. Thank you. Thank you, Caitlin. Certainly we will have a debate. We were a little late, so instead of ending at 6:30, we will end 6:45. We have time for the last presentation of Natalia Lima, who is the compliance officer of Huawei in Brazil. And this is a company that receives a lot of attention from the regulators, whether from data protection and security, because in the last 2 or 3 years, the company needed to develop a huge amount of attention for these issues. And it's interesting to see how you, from Huawei, a Chinese company with a global presence, how you developed your approach to try to develop an artificial intelligence that is more responsible and more responsive as possible. Good evening, everyone. So getting the link of what Professor Lucas said, to Huawei, it is very important, the risks. Everything about compliance and governance has as a base the risks of what technology and the development of these technologies can bring to society, to the business, and to all the sectors. Because of that, we always have this topic in mind. And about artificial intelligence, we believe that in order to have a responsible artificial intelligence, we need competent people and people who already know these subjects since the first layer until the last layer of artificial intelligence. When we think about systems, for example, we need to make sure these systems are robust, are stable, and traceable, and it's possible to explain the logics behind the decision making, all the trajectory until we make a decision. And it's not only that, we have the concern with the data protection, as it was said here. AI uses massively the personal data, sensitive data or not, and because of that, internally, we are focusing on the quality of this data. that this data can be full, can be accurate, because a contamination or an attack on this data can bring serious consequences related to the decision making. That's why Huawei focus on governance. When we talk about artificial intelligence, we usually say that it is connected to the development of one thing. We cannot talk about one thing without talking about the other. So in this aspect, we always try to make these assessments and analysis from time to time to see the impact of these technologies and the controls. The controls are really important. We consider that the deliberate use of AI can cause many damage. And because of that, we have a team, a multidisciplinary team, because considering the application of artificial intelligence in many different sectors, we need people from different sectors to talk about the subject since the development until the application. And to us, this is important. We need to make this filter of risks and to make the risk analysis. And we need to have a technology that is good. We always focus on the issue that artificial intelligence has to be healthy, has to be responsible. So we need to have these controls in place and this whole team that we can make a proper use and as healthy as possible of this type of technology. As it was said here, the biases and the discrimination, we have to focus on making that not happening. So this is important because of the psychological and economic damage that this might cause. And because of that, the company is focusing on this type of governance and controls and policies and responsibilities. We are also very anxious and we are following closely the legislative initiatives that are happening in Brazil and all over the world. And I just wanted to bring this part of governance and what Highway is doing in terms of the risk of this new technology. And thank you very much, Professor Luca, for the opportunity. Before the conclusion of our Professor Nicolo, I'm going to open the floor for questions and comments. I'm going to reaffirm, as I said yesterday, please ask questions, not comments. So, questions that are 30, 40 seconds long. Otherwise, it will be a comment. So if you have questions, please, you can raise your hands. There is someone here. You can pass the mic. Okay, raise your hands so we can see where you are. Hello, my name is Lucia Camacho. How do we imagine a strategy to fight this practice of regulatory dissociation, that the companies participate in the governance environments, they support regulatory processes, and at the same time they make lobby against the regulation. They sue the authorities that issue decisions to apply the law, as the case of Colombia. Decisions that are being questioned, not to be applied. How do we fight this regulatory dissociation that Max also presented in the meta presentation? What to do? Okay, everyone can answer about this schizophrenia and how the regulators can become therapists. There are other questions here, otherwise we'll start with this one. Maybe Max wants to answer first. And then we pass the floor for everyone to make an opinion.
Yes, yeah. Thanks for the question. So I think, at least from a European perspective, and that may be very different, we have a culture problem here. We have regulators that were not used to enforce stuff. So they usually didn't have powers to enforcement. They don't know how to investigate the company. So I oftentimes said if we would have a new regulator in Europe, if I would be the politician, I'll probably put financial regulators in there or criminal investigators into the data protection authority, because you need a different mindset. And to maybe get one step back, I was studying in California before I started with all of that. And we were trained in California to say, how likely is it that there's going to be a consequence? That was our training in law school. How likely is there going to be a fine? And does it make a business opportunity to break the law or comply with it? It's a very different culture mindset than we have in Europe. Usually we're trained to, the law is the law, there's still wiggle room, but so this mindset is the problem that we then had to have these huge fines, the 4%, which I'm politically against. I think, we shouldn't hammer higher and higher, but we're, especially with the Silicon Valley, having a mindset on the other side to absolutely ignore law at any possibility. And we see that, for example, now with Apple, when it was about the DMA and how to do the market, how to open up their Play Store, however it's called on Apple, to kind of bypass and just play with the regulator. And I guess, I think from a European perspective right now, we're kind of the ones that tried and still fail or are in this negotiation, because on our side, I think the regulator doesn't have the balls and to actually do it. We had a conversation before that in India, they're worried about the government because there's actually consequences. I think in Europe, we are good at passing these laws, but actually when it comes to actual consequences, they're not there. So when we talk to data protection officers within these companies, off record, not officially, they usually tell us, yes, we know it's not legal, but I don't get my CEO in somewhere in California to actually agree to invest money into that, because as long as there is no business consequence and no drama, we're just not going to do it. And to open up that way back, it's a matter of democracy. It's a matter of rule of law. You can disagree with the law, and I disagree with the GDPR a lot. It would probably be half as long as if I would have written it. But we still have to accept that was 90% in the European Parliament passed, that this is now the law of the land, and that we actually enforce that. And it's really interesting because in the digital sphere, that's somehow accepted that you don't comply with the law, where we would never accept it in the other sphere. And that's, I think, the reason why, as a lawyer, I'm still working in this area. It's really interesting because the delta between reality and law is hardly ever that big as in this area. And that is, I think, where we have to move forward the next years. And that's kind of what we work. But I think maybe we had a conversation before on that, how, for example, you said in India, actually, a lot of the companies do comply because they're worried enough that there is a consequence. I don't know if there's different approaches that work better.
So in India, quite often there are companies. In fact, the thing about the internet ecosystem is that what we call innovation challenges the boundaries that have been created by regulation. They operate in gray areas, right? Crypto is a classic example of something that's operated for a while in a gray area as well. A lot of fintech innovation happens where regulation doesn't actually exist. Wallets in India started in the same manner. What eventually happens is that when they gain enough market, when they have enough users, third-party liabilities come into play, and regulators then don't want to shut that down because of the consequences for consumers in that process. So many companies actually bank on this idea that we will create products where there is no regulation, where there's a gap, and then when the regulation comes in, it'll have to be created in consultation with us, and we'll comply when that happens. In India, quite often, regulation is such that it's so broad quite often that companies invariably are in violation of the law in some shape or form. And the government or the regulation only gets enacted when there is a problem. Then they throw the entire rule book at you. So I wouldn't say that it's companies are complying or doing certain things only because they're afraid. But the fact is they're always in violation of something or the other. So they know that they'll have to deal with regulatory action in any case.
Anybody else? So the question, I think, has to do with two contexts. First of all, the company's context, which I consider from the company's rationale, which it believes is legitimate to play in these spaces. They're protecting interests that they consider to be legitimate. And let's say in the Google case, for example, it's interesting, this decision from 2019, 2020, that was by Delegate Remolina at the time, that considers an idea which today we consider to be common, that has to do with applying territoriality to data, right? So companies with their data, they are submitted to the national law. And this means, you know, there's a debate around this. However, Google, before the administrative judge, I believe they said, okay, there's an uncertainty about what should happen here, right? To put to the test the rule of law and the legal culture of judges around data, right? So there are several gaps there. And this idea of territoriality and thinking about the law and how to reimagine it and international law, extraterritoriality. But then when we speak about administrative laws, which are local, built under the concept of sovereignty, this territoriality is quite sophisticated for an administrative judge. And here, what I think is important actually are two things for this answer. Number one, the independence of the authority before the market's actors, before the big techs. I think this is the most important guarantee, an independent regulatory agent that is not affected by or co-opted by these actors. I think this is fundamental as an element, right? This could be an obstacle and things need to be clear. It would be a fundamental guarantee. The second guarantee that I think is very important has to do with the culture and the capacity of the judges to reinvent their jurisprudence to approach these new problems where they will not find answers in the contentious administrative codes. They won't find clear answers in the law. So here the judge needs to imagine and understand the concept under comparable law, international standards, and they need to understand that the data are regional and global discussion and then issue their sentences according to this, right? Thinking of this constitutionally, I would say. So, you know, I think naturally the companies have this behavior, right? They want to maximize their benefits, their profits, and that's how they operate. And in this nature of maximizing benefits, then we need to think of the nature of the rule of law. Well, its nature should be to guarantee rights and to face these companies and to discipline the market strongly. So they need to answer to these companies by enforcing boundaries and limits. And there are some jurisdictions that are exceptions, like maybe the Italian jurisdiction, the French jurisdiction, the Spanish jurisdiction. They have given us some key elements in terms of how we can stop these dynamics that are instated. But in Latin America, the judges are now facing this big new challenge, and Luca is working in the Inter-American Statement on Rights because we need to create a standard for regional protection of rights, but that can be applied to the national jurisdictions as well. It needs to be applied nationally and to be oriented towards the national law. And the administrative judges need to be able to understand this conventionally, following the conventional logic so that they can apply this. Today, my concern is the national judges, the legal culture, their background, and their capacity to understand these new challenges. Do we have more questions? Okay. So I think we're gonna finish. I think everybody was expecting this moment. Our dear Professor Nicolo will be making the closing remarks. I have the honor and the burden to be the last one to speak at this event. So I want to say I'm very pleased to see that after 4 years, we have been able to build this very active community that is sharing such interesting ideas. So firstly, I have prepared here just a list so you have an idea of the numbers. We have 287 participants, 27 sessions, parallel sessions, 2 plenary sessions, very varied topics such as data governance in the G20, regulation of AI, digital identity, data and competition, sandboxes, privacy enhancement technology, cybersecurity, portability, discrimination, algorithmic transparency, and digital public infrastructure. So I would like to, of course, thank on behalf of Luca, all of you for contributing such important perspectives. We have received many compliments, but actually, as he has already anticipated, all of this is thanks to the quality of the people and the ideas that are here. And of course, we're all willing to be in this debate and this dialogue, right? We have always highlighted the importance of this multi-sectorial dialogue, people from different sectors of society present here so we can have a constructive dialogue that is reciprocal. From the beginning, our idea was, okay, we're going to create a platform, a Latin American platform, to discuss data protection, privacy, and technology. And we started in a very challenging way during the pandemic. The first edition was fully online. And so we tested some things out and saw what the interest was for this type of event. So in the beginning, we divided this between a multi-sectorial discussion and one that was more focused on technology and innovation, which was the My Data part. And now we have realized that it doesn't make sense to divide them. So now My Data has become simply a part of this, right? A part of our schedule. And we have these sessions that are more focused on the control of the control that individuals and collectives have on personal data. And right now we are thinking about building other parts or segments, let's say, that could be interesting for the future. So we could direct this more for people that want to be focused on some aspects that are more specific, or some that don't know the conference but that are curious, or some that are kind of lost. And I feel identified here because of so many things we can choose from, considering all of these topics. So please feel free to make your suggestions here if you think we can create new segments, or if you have new ideas on how we can organize this event in the future. This would also allow us to direct our conference so it can be more and more Latin America. We were inspired in the Brussels conference. This is our sister conference. And so we have this collaboration with them. And thanks to that, we have heard from the European perspectives. Now, about the substantial part of the discussion, I want to make 3 points here. First of all, we see there are many challenges that are shared in the region. So it doesn't make sense to address these challenges in an isolated way, and which sometimes creates conflicting solutions. In this sense, it's very promising to see the advancements in the jurisdiction in the Inter-American Court of Human Rights, in this case with Colombia, and this proposal that was launched yesterday in the CPDP LatAm website, a representative of 5 different countries of Latin America. However, even though this proposal and the conference give us a good base for discussions, this is a first step, right? So we're just getting started in this process, and there's a lot we can do to improve the regulatory framework, specifically regarding data governance, and also acknowledging the role of data as an essential asset in the digital economy. And it's very encouraging in this sense to see that, for example, last week, a decree was approved which attributes to the Department of Innovation and Technology of the Ministry of Development and Digital Trade a competence that is related to improving laws that acknowledge data and the data economy. They will be conducting a public consultation on this topic very soon, and I think that is important to show that there is a need for society's participation to build the regulatory agenda on data governance. And this follows a lot, I think, the model that Brazil adopted, and that has to do with the civil framework for the internet. And at the same time, the public consultation will also be something very challenging, I think, for the future with the use of generative AI, right? We can imagine how many answers can be submitted to this consultation and people using ChatGPT or other similar tools. So are we prepared for this or not? We need to consider this aspect. Something else I want to highlight that expands the social participation is the access of researchers to data that has to do with how AI works and these complex processes that are being conducted within these black boxes, let's say, of several companies. So here we have several bills of law on the regulation of platforms and the regulation of AI. And they consider dispositions that would give the access of selected researchers following some criteria. They would be able to access this data for research so we can better understand these aspects. Here, the problem is that we need to define who these researchers are, what kind of research is legitimate, how do we verify they are following the law, and not just data processing laws. But for example, in the proposal of regulating AI, there is an exception there for research that has to do with training and data mining. That is research related, and this could potentially be used by a researcher to then create and commercialize a product. So we need professionals that can conduct this kind of verification, the auditors. So the auditing of the processes is something that helps the regulators to deal with this complex world that we are facing with AI and the massive treatment of data. In this sense, the regulator has a challenge, and I think, we can highlight, in my opinion, the educational stances of the authorities. Here they have chosen a responsive regulation, trying to promote dialogue, trying to educate the population. We see this as a preventive measure as well, as something that was conducted, thinking about an emblematic case from a company. So here they identified a case that could serve as a lesson to the whole sector. And I think this approach allows us to generate a sort of efficiency in the monitoring of the market. Having said that, now I want to speak about something very important that we will address in our agenda tomorrow, which has to do with digital sovereignty. We will be debating and explaining how this sovereignty is not just a government prerogative, for example, for avoiding us being dependent on the big tech companies from other countries. It also is a possibility for the communities to have more controls over the technological controls that affect them and have an impact on them. So we will have several discussions on the various dimensions of sovereignty. And so I want to congratulate, first of all, Luca, who, as always, is relentless in his work and has organized this third day of events after being a true force of nature in organizing all of these debates. So, a round of applause for Luca. I think it is well deserved.
And also, Josie, I want to thank the team of the Center for Technology and Society for the contribution in the organization of the event, especially Ana Beatriz, Walter, Giovanni, and João Pedro. Thank you. And I want to conclude saying that everyone is invited not only to the debates tomorrow, not only to participate in the event next year, but also in the construction of the agenda. Feel free to make suggestions of topics, people, formats. So we are here to build something together. Thank you. So that's it for today. Tomorrow we have more.